We're live.
Okay, great. And so since I'm the host, am I the only person that can admit more people? Is that the way that works?
Oh, is that happen? Possibly. James, are you not able to admit people now?
Man.
Sorry, everyone, for the technical issues.
It's okay. We'll sort this out.
We're like 2 years into this whole thing and we still can just barely figure out how to use Zoom.
So I have 3 folks in the waiting room. Should I just
Great.
admit them?
Yeah, just at this point, just let them in, I think is the best thing. And then we're going to get going in a minute. Oh yeah, a bunch of people there coming. Sorry, Kendra and Paul, do you guys mind taking your video off? I'm sorry, I bungled the settings on this, I think. So people's videos are showing up, and we just don't want to clutter the screen too much. Apologies. Okay, so it's 2. Not sure if there's anyone else in the waiting room. If you see them, you can let them in, and if not, we'll get going. So welcome everyone to the first webinar, first CLC webinar of 2022-23. My name is August Murphy King. I'm the General Manager of the Canadian League of Composers. We are joined today with by Burt Gidaro and Byron Pascoe from Edwards Creative Law. These are the folks who helped draft our new model commissioning contract that is available on our website in both languages. And today they will take us through that in some detail and hopefully that will help illuminate the document itself. And of course, if you have any questions at any time, put them into the chat and we'll make sure we get to them at the end. But before we get going, I would just like to acknowledge that the Canadian League of Composers, sorry, my screen has disappeared. The head office of the Canadian League of Composers is located in Takaranto, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. It is now home to many diverse First Nations, Inuit, and Métis peoples. It is covered by Treaty 13, signed with the Mississaugas of the Credit, and the Williams Treaties, signed with multiple Mississaugas and Chippewa bands. And I would encourage you to take a moment to reflect upon the land on which you live and how you can contribute to the ongoing process of truth and reconciliation. So with that, I'm going to turn this over to Burt, who's got a deck prepared, and I will keep an eye on the chat for questions. But without further ado, let's turn it over to Burt.
Thanks, August. Thank you very much. My name is Burt Gidaro. I am a lawyer with Edwards Creative Law, and we are based in Ottawa and Toronto primarily, but we do serve all of Canada, including Winnipeg, and we have, a lawyer that's basically at the Winnipeg office as well, sort of bi-provincial, and we do a lot of business in BC as well. So we were privileged to get to work on this template commission agreement with the Canadian League of Composers, and it was a fun project for us, where Byron and I are both, I would say, music. We specialize in music law, let's put it that way. and we have a background. My background too is that I'm actually a music grad before I became a legal grad. And my specialty in that regard was more on the composition side too. So this was a lot of fun for me to put together. And Byron, of course, was in there deeply as well. And I will just talk about this particular kind of agreement too, because I just think it's pretty specific. There are composer agreements of a couple of different varieties that we get into, but by far the ones that we're asked to do the most are ones that relate to commissioning music for an audiovisual work like film and television, or perhaps a video game. We do those kinds of contracts too. This is one that was interesting to us just because it was us looking at commissions more on the classical side, more of ensembles that are looking to deal with composers and commission works in that way. So that was very interesting for us too. And we used we at least started as a starting point with the prior composer commission agreement. We just tried to make it as good as we possibly could based on reviewing the terms and conditions of a lot of composer agreements from around the globe. Really, we looked at a bunch of them in the English language, obviously, and then in the French language too. So there's two versions of this. So I did want to get started here, and we thought what we might do to hopefully make this somewhat more engaging is play roles here, because this is really you're talking about two parties here that are asking for something out of the arrangement which the agreement would enshrine. And so I will be playing the role of the composer here, and my colleague Byron will be playing the role of the commissioner, and just going through what a typical negotiation flow might look like based on we've done a lot of these sorts of things, but it's really about what does the composer want out of this, and what does the commissioner want out of this, and what's that dance like. So with that, we will get started with the first slide here. So the first provision in the agreement is really about the commission and what is the subject of the commission. So it's the musical work and as embodied in the performance score that you folks would be composing and delivering to the commissioner in that case. So I don't know if you wanted to get started on the role play here, Byron, but
Sure. Well, before I do, just a quick note that this presentation is not legal advice. This is legal information that we are sharing. And if you have a question about your specific circumstances, please consult a lawyer to discuss. So that's our legal disclaimer that we have to say every time we do a presentation like this. And I guess just a couple, one other kind of background comment is that this agreement can be used when you are being commissioned to produce work. You may alternatively get an agreement from a commissioning body, and your response might be to say, well, can we instead use this model contract from the organization, from Canadian League of Composers? So sometimes the question will be kind of, how do you get towards using this agreement in practice? And it just kind of depends on the circumstances, but it may be a discussion with you and the commissioning body regarding how you're going to formalize the arrangement. No pun intended, of course. But yeah, so I'm going to be playing the role of commissioner today in this role play that we're going to provide regarding some of the terms of the agreement. And then Burt will provide a bit more detail regarding some of the other elements of the clauses. And the last point is that everything you see on the slides here, it's all aspects of just copying and pasting from the actual agreement that's on the website. So there's nothing on here that you don't have access, apart from our contact info. There's no substantive information on the slides that you don't already have access to in the actual agreement. We just merely copied and pasted the clauses, and we're presenting them here. And the only other thing that's in the agreement, but not our slides, is where it lists who the parties are, and where everybody signs. But generally speaking, the options are that you're signing as yourself, or perhaps you have a company, perhaps a corporation that is loaning out your services. So, the you is either you personally or your company, and the party that you're entering into the agreement with, they might also be an organization or a corporation or an individual. So it's set up to deal with all of those circumstances, and that's what I want to say about that. So yeah, regarding commission. Burt, composer, I'd like this work that you're doing for my organization to be the only thing that you work on until it's done.
Okay, well, if I'm taking that on as an exclusive commission, that would mean that I have to give up other composing opportunities that I have to make, more money. So and I'll give you my thought process, which is you're either going to have to pay me more money for this particular commission, so I'm not losing out on those opportunities, or I can't agree to that. And just being exclusive to you, unfortunately, doesn't work for me in that time frame.
Okay. Bert, I'm going to accept that. I'm okay with this being a that this is not the only thing you're working on. We can go on to some other topic, Bert, whenever you're ready.
Okay, great. So everybody's favorite, financial compensation. But we're not there yet.
That's right.
Sorry. So the musical work in the contract itself is going to be provided on a non-exclusive basis. And so there is an exclusive performance period set out in 5.1. So that's different than your exclusive services as a composer. The exclusive performance period means that there's maybe, and this is typical, a period of time where the commissioner gets to perform the work and not have another ensemble perform it in that same time to give it some, and that basically preserving that exclusivity gives it some cachet, and they paid for it. So that's typically a right that they do get. On to financial compensation here.
So, Bert, I'm suggesting that I pay you $7,000 now, for this project, and I'm willing to give you a percentage of profit so that you can earn up to $12,000. What do you think about that?
Well, I think I'd rather get the $12,000 guaranteed, just because, and again, the thinking process is, I don't know if this will be attended well enough for us to ever get to that $12,000 mark. But if I get my money up front, then I know what I'm getting is guaranteed.
Well, I'm willing to have your compensation be guaranteed, but I'm not willing to give you 12,000. But I would be willing to give you 10 if it's not contingent on how everything goes.
Okay, and so that would be guaranteed. Maybe if it's 10, would you give me a share of revenues as well in addition to that? Because my expectation was I would be making 12K on this.
Well, I can't do that, but I'm willing to bring it up to 10,500 without any sort of contingent compensation. Or we can go to, back to what I suggested before, 7 and up to 12 if there's some contingency. So either guaranteed at 10,500 or guaranteed 7,000. But this is going to be great. It's going to be great. There's going to be revenue there. So it's up to you. But I definitely, if I'm guaranteeing you the full amount, then it's going to be less than what you would get if you had some of the funds be contingent on financial success.
Okay, well, I think that's acceptable, provided there's not anything that ends up having to be refunded if we end up not being as financially successful as you're projecting. So if everything's guaranteed and not contingent, I can accept the $10,500.
Okay, now I want to pay it to you when I get the final score. When everything's done, only then am I going to pay you anything. Okay?
No, not okay. I have to live as well. So I would like something on execution of the agreement, just as a show of good faith, and that you're in it, and you've paid something. So now I can go ahead and start sacrificing my time because I have a little bit of money in my pocket that shows me that we're in this together. And then we can work out on the basis of maybe a milestone schedule as to what the remainder of the contingents the compensation is going to be. Not that it would be contingent, but that it would happen on milestones. And so let's say, taking a look here for what we could get into for the milestone schedule, but with a little bit of a holdback for delivery of the musical work.
I'm okay with that. I don't like it, Bert, but I'm okay with that. I understand. But what about if I don't like what you produce? What then?
Oh, that's interesting. Well, you're going to love what I produce, first of all.
Well, I know. I mean, we're having a conversation. I did speak to some other people, and I know your work, and this is why, people. I'm being told I need to work with Bert.
Yeah.
But just in case, is there any sort of meaningful consultation we have the commissioning body here? Is there any involvement at all?
Yeah, I think I can provide that, but the ultimate approval of this is an artistic work.
Yeah.
And again, I'll make a comparison because I do composing for film and television as well. In that arena, there's more approval given to the commissioner of the work in terms of the artistic work than there is in this case, because those are commercial endeavors. And not that this isn't a commercial endeavor, but I'm here making art music. So approval of the final score has to rest with me. But if you have light notes, perhaps we can provide for taking your notes into consideration and potentially making one round of revisions on that basis. But ultimately, creative control has to rest with me.
I can handle that, Bert. Okay.
Great. Done. This is so easy. So that was sort of to illustrate, at least in part, that you're going to get paid on a schedule. And so what we recommend is, and practically speaking, I studied composition and I composed, but I haven't done this professionally or delivered a professional composition in a very, very long time. So, think of what the milestones are that, maybe it's 20% of the compensation, 50% upon execution, but 20% upon, delivery of, say, the score, 20% on delivery of or at least an initial draft of the score, and then maybe delivery of those parts. Right here, we have final delivery of the musical work at 10%. And you wouldn't want to make any of it contingent on, say, the performance of it, because that's not really anything that's within your control. So I think when you try and put together a payment schedule, we're always looking for things that you as the person being commissioned has control over, and isn't, sort of being hung out there by the commissioner, that they have control over, and then they can, they either delay through no fault of their own, or they intentionally delay because they don't want to pay as soon as they need to pay. And that happens. And then, of course, compensation or any installments of the compensation shall be non-refundable. Okay, delivery.
I think that my comments about the meaningful consultation and such were actually focused on this clause. So
right,
we've already done a bit of our back and forth on the delivery.
Right. What about, okay, so I need to know when to be able to produce this for. What are we looking at in terms of delivery dates, etc.?
Yeah, and a lot of this, it references Schedule A there, and we'll get to Schedule A at the end. But a lot of times, some or all of the specific numbers and dates, et cetera, are listed in a schedule outside the scope of, it's in the agreement, but it's in a schedule that lists a few different things. So there will be a slide later in the deck with the proposed Schedule A items.
Right.
But the agreement does refer to Schedule A few times.
Yeah, and to that point, it's like there's a lot of nuts and bolts stuff that goes into the Schedule A. It's like very specific stuff with respect to the musical work and the parts and all those sorts of things. That's typically going to be in Schedule A. And I think, you know, the thinking there is to keep the agreement very much, you know, agreement in terms of what the financial compensation is, what the obligations of each party are, and that's more properly what goes in the agreement by itself. But Schedule A is really nuts and bolts, and really that's the stuff that if let's say Byron and I were acting for you as your lawyer, those are the things that we'd be looking to you for to provide to us, because that really hones in on the composers or even the commissioner's area of expertise in terms of what it is that they want. So that's kind of the thinking.
A related point there is just that it's good to clarify those things so that there aren't misunderstandings of expectations. That the last thing that anyone would want in any kind of agreement is that all of the parties have different expectations of each other. And so that's really kind of one of the key reasons why to have an agreement in the first place. It's to clarify as much as you can so that your expectations of each other are consistent and clarified to the extent possible.
And I would agree with that. And I think, you know, just because it's put in a schedule doesn't mean that it's not important. In some ways, some of the stuff in the schedule is the most important stuff, because it really often you'll find a scope of what it is you're supposed to do in the schedule. And that can change, you know, it from being, you know, a money-making proposition to something that's like so onerous. And when you work out your time against the amount of hours that you have to spend to it on it, it's like unworkable. So the schedule is really, it's just because it's at the back of the agreement doesn't mean it's not very important. Okay, so like these are some of the things that in terms of delivery that have come up as well. And I don't even know if there's any role playing that needs to be done around this, but basically the copying of parts for the musical work is the responsibility of the commissioner. So that is something we put on the commissioner so that you're not you know, spending a lot of, first of all, that's not composition. That's more, you know, a clerical type of thing in the composition process. And then you as the composer would have the right to inspect and either approve or disapprove the parts before the first rehearsal. So, and that's another thing too, right? Because maybe what if what's being put in the parts isn't what you had specified in the score for the musical work. You're going to want to make sure that everything lines up so that the integrity of your work is maintained by the musicians playing it. And then, you know, there's provisions for time in terms of when there's a disapproved portion. So, you know, then and then there's deemed approvals that end up happening too, because a lot of contract in terms of contracting and figuring things out, a lot of it has to do with the timing. And so if there's unreasonable delays, then, you know, that can set the performance back as well. And so we put in what I think is a reasonable amount of time for you to have to respond in, but that's something that you can always pull out as well if you're not comfortable, or you can amend. We've made a note on the agreement itself that if you need longer than 30 days to go through the receipt of the parts or the parts themselves and make sure that they line up with what it is you need to see, but there will be a deemed approval if you don't respond within that amount of time. And that I'm pretty sure came from that. It must have come from the earlier version of this agreement too. And here we go. This is what Byron was talking about before, which is the composer shall provide commissioner with a right of meaningful consultation with respect to potential changes. For clarity, the composer shall have no obligation to make any of the changes to the musical work as delivered or as a result of meaningful consultation or otherwise. So really, this puts you in the driver's seat here. And again, I made the distinction between, doing something for a very, centered in a commercial purpose like a film or television versus, you're creating a piece of art music for an ensemble that's commissioning it, and you should be in control as the artist that is producing the piece of work. I noticed we have a question in the chat. What do you think? Should we? I'll just answer questions, and then if it starts getting to be a lot of questions, we can just maybe kick them to the end.
Okay, we can do
Kendra,
that.
is that good? Okay, great. Kendra has asked, would you ever put in the agreement that the composer would do the copying, or would that be a separate agreement? I would think, you can negotiate these things as you wish. I mean, if they're paying you enough, or if the commission is valuable enough for you to do that for them, that's kind of your, it's your prerogative if you want to do that. I would say, I think the starting position ought to be, though, that they should copy the parts, because that's not an easy thing to do. It's on you when you have to do that, deliver all the parts for performance. And just, I wouldn't put that in at first. That wouldn't be my first position. I put it on them. And then if they said, we can't do that because we don't have resource X or Y, or it'll take us too long, then, you can make a determination at that point what you're willing to give on that point.
Could I just quickly ask a follow-up on that? That's related.
Yeah, absolutely.
If you were in a situation where the composer was going to hire or contract their own copyist, would this be this? But then have the bill for that picked up by the commissioner, would this be the place to put that sort of adjustment in?
I think that's right. It's like it will be the it'll end up being the responsibility for the composer to arrange for the copying to occur, but then you can put down that the commissioner will be financially responsible. They'll probably put they'll attach an amount to it, whether it's, a top end limit or, just an amount that they'll pay for that. But I would put that there. And maybe that's something that, if it's coming up and it seems like, that one of the things we want to get to as well is that if some good ideas come out of this discussion, we can look at sort of amending the model agreement to include like a variation. So if you need some language in order to put in there, we can provide that.
Okay, great. Thank you.
Thank you. Okay, great. So let's keep going here. Term. There's not really much to be said about this one, except that the term of the agreement will commence on the effective date, which is often the day that you sign the agreement, or maybe some earlier date, and continue until the expiry of the exclusive performance period or any extension thereof. And so really, once that exclusive performance period is done, your contract with them, the term of it is over. There are going to be rights and obligations that survive, and we'll talk about survival at the end of this, but really the agreement at that point, the term of it is at an end. So let's move on here. Rights and obligations of the commissioner.
So Burt, I'll just jump in with some more things I'd like. I want to have the exclusive right forever to use this work that you're creating. Good? No, it isn't. I mean, so I'd have to have like a period. I obviously recognize your right to have an exclusive performance period because you're commissioning this, and without you, in some ways, the piece wouldn't come into being. But no, I need the right to be able to, this is my work, and essentially, whatever other rights I get in it, I don't get to exploit those rights because you're the exclusive ensemble that gets to perform it. So how long? Maybe 3 years from the last performance? Is that good?
I think some of my composer compatriots on this call could help us out with this a little bit better, but the period of time that we have that I think is good is like, 30 days from the time that it's actually delivered, and you have you have an ensemble that's ready to play it. You basically have a 30-day period from the first performance of it until the last performance of it. Hey, that's actually pretty good, because in some cases you get one performance only.
Well, I'd like a bit longer, but you know what? We can deal with some other stuff.
Okay, cool. Maybe we'll come back to that. So that's it. I mean, like, the exclusive performance period is really about just that. How long does the commissioner get it exclusively, where you can't shop this or make it available to other ensembles to play? And what's reasonable? And often, if the commissioner says, you know what, I'm going to pony up a boatload of money, and you might be willing to extend that exclusive performance period for them because it's worth your while. But really, you're granted, we'll look through the rest of the agreement, you're granted other rights in this that you can go about exploiting. And it's like that same idea that if you're going to be providing exclusive services to somebody and you miss out on other opportunities, if they exclusively tie up this performance score, then, or the musical work, then you're missing out on other opportunities for others to exploit the IP and to monetize it. So that's the thinking. And then, what we've included as well is a provision that allows for the commissioner to extend the exclusive performance period. Let's say things are going really well with it and well received. People are coming to see it. It's generating money for them. That's fine that they would extend it, but we would want the extension to be fixed, and we would want to know what payment you would be getting in relation to that extension. I think that's fair and reasonable. Okay, well, here's another one that's helpful. I think helpful to you is that if the commissioner owns or controls any recordings of it, that they have to make them available to you too, right? And that's if you allow them to record it too, because that's a different provision within here, but that's something that should be within your control as well. And typically, we'll get to that in a second. I'll actually look at it in a second. And here's that second. When we're talking about archival, usually a commissioner is granted a right for archival purposes to make recordings of the musical work. And then, it's really just that they're able to keep that for their own purposes, but that doesn't mean publicly displaying it or monetizing it in any way. It just means that they're allowed to have the copy. Here's another one, which we saw somewhere and thought it made a lot of sense, that you would be able to get 2 complimentary tickets for the first performance, and then the commissioner must give you some notice of that so that you can plan to attend. So advertising. So you have control over this, but they're also going to want to potentially be able to put this out via media to promote the performances. So if that's the case, then they have this ability, but they only can do that with respect to promotional uses of it. And anything where would be monetized, I would argue, falls out of promotional performances. In terms of promotion, the commissioner shall have the right to make a finished edited recording of excerpts of its performance of the musical work for purposes such as, but not limited to, demonstrating the nature of the work, showing it to potential sponsors, donors, and investors. Commissioner will guarantee that the recording will remain under its control and may not be used for the public at large or commercially. So again, this is a broadened right for them to have recordings of excerpts of the work to show to donors, show to sponsors, so that they can do what they do as an ensemble. But the commissioner is going to control that, and it's not going to be used for the public at large. And if there's instances where a third party wishes to record the performance, the commissioner shall A, inform the composer, B, inform the third party that the composer is the copyright owner of the musical work and inform them how to contact the composer, and C, not permit such recording without prior written approval from the composer. So, I've had this happen in a more commercial context, but there's some strict provisions that it will not be recorded, and then there are videos of it, with sound recordings being put up on YouTube of these things, and it's because the commissioner allowed somebody to actually record it when it's not ideal. You'd want control over your over who records it and who's putting it out there as well.
So, what role exactly are you going to have with the preparation of this performance? Are you going to be there all 24/7? Call you anytime?
Well, I'd want to.
You live in Winnipeg, and the performance is in Newfoundland, but you can, flights and accommodations are included in your fee, right? You're at my beck and call.
No, no. I would like the right to. How about? Well, not that. If you don't like no, then I'll just say, how about something different?
Sure.
Which is, in this case, I want the right to be able to attend all the rehearsals and the performances of musical work, but I don't want to have to foot the bill for coming out there and having to be at every single one of them. And I also have, I have faith that after we've gone through all my changes in directions, etc., that at some level you guys are going to do what's, I have faith that you'll respect my wishes in that regard too. So I probably don't need to be there. I can give you some of my input, but I would like the right to be there.
And Burt, do we pay you? Do we have to pay you if you come out? If you're helping out?
I guess that depends, right?
If the rates, or is that included?
Well, that's something that maybe we can discuss, and we'll think about it in terms of what, how much budget you've had in order to put this on, and whether you're flying me out from Winnipeg to St. John's, and we'll take all that stuff into consideration. But I can give you a rate, and that rate is, I'll give you a per diem, and maybe I'll get back to you with what that ends up being.
Okay.
Right. So here's the fees
section here. We can list the rates that for what you have now, and as we get closer, we can figure out if how much time will actually be needed. And do you have a full day and a weekly rate there too?
Yeah, I've got like a half day workshop rate, and full day workshop rate, and I've got something for 3 or 4 more days in a week.
Okay. Well,
and I will send that on.
Put in the numbers that are your standard, or you can help me out a bit and keep them down a bit. But either way, let me know what you're suggesting. I'll go back to my team and let you know.
Great.
Okay.
And so at the end of that role play, I'd actually ask for some input from the people on the line that have, if you have some suggestions or benchmarks for what it is that you guys charge for these kinds of things, that would be something that you'd want to share, I would think, internally, as part of the league, because that's an important part of belonging to a trade organization, is that you share information. And one of the I know with lawyers, when we see a lot of a particular kind of deal, people come to us and ask, hey, what's the going rate for this, or what's the going rate for that? And that is one of the most valuable things that we can actually provide is a benchmark, just to make sure that you're being treated fairly, And then, a little bit more here on, if the composer has to travel more than 50 kilometers, then there would be overnight accommodation and round trip air or other available appropriate transportation that way. All right, just need a sec here. Great. Yeah, and then there's a bit of press that you may end up having to do, which is something else that you should be compensated for, or at least there should be notice given to you, etc. So, and if there's anything else that they want you to take on, it should be the subject of another contract, right? And then, also an understanding that the commissioner wouldn't be liable for duplicate payment of travel, accommodation, per diems, or other related expenses, which seems fair to me. Copyright.
So, Bert, I assume you own the copyright here of this work, but there are some things I just want to clarify of what well, you let me know, Bert. What am I able to do if you, as the copyright owner, well, first off, are you the copyright owner? Do we share
Yes.
that? Okay, I guess that seems reasonable or standard. Am I, to what extent can I print materials from what you're making to distribute to the actual players? Tell me what I can do and what I can't do, and then I'll let you know if I think I need anything else.
Okay. Well, to the extent that you have to print out parts or make copies of parts in order to make the performances happen reasonably, then you have the license to do that. You have the right to do that. You can't really do anything beyond that. Like you couldn't sell somebody else a copy of the score or provide them with a copy of it. That's for me to do. But really, I'm going to try and give you all the rights that you need in order to affect these initial performances that are going to come out of you having commissioned this.
That seems fair.
I thought so. So the composer is going to be the first author and owner of copyright in a musical work. The composer is going to be free to deal with the musical work, subject only to the rights granted to the commissioner. Commissioner can't make changes to the musical work or the performance score without the composer's prior written approval. And the composer reserves all other rights not specifically granted herein. So just protecting your rights. And then, there's no, as a first position here, there will be no financial obligations to the commissioner or credit them, etc. I think, crediting or thanking is probably less of a problem than providing them with some ongoing financial compensation. It doesn't make any sense. Like they're doing a commission, they're doing it for their own. They're doing it for their own ensemble. The ensemble will play it, and there's prestige in doing that. So you should, as the composer, get all the rights to the work going forward. And then this is the license that I was talking about, Byron, in terms of them having the ability to reproduce physical copies of the musical work to the extent necessary for the commissioner to rehearse the musical work and perform the musical work for audiences during the exclusive performance period, which is fair, right? Like anything beyond that, they don't need. Okay.
Yeah, that it's oftentimes in any kind of agreement, music or otherwise, sometimes people ask for more than what they need, and the response that we say is, well, what do you need? Okay, you don't need any of this other stuff. So we're not suggesting that our client give you more than what you need to do what you want to do. Okay, royalties. So, Bert, I think that since I'm, paying you funds so that you can create this, that I want to share I want to be allocated some of the money that is generated through public performance royalties. I think I should be sharing in that with you. What do you think?
I think that's not what we're going to do. So I as a composer shall retain 100% of the composer royalties here. It doesn't make any sense. You're putting on a performance through your ensemble. I know you're having something to do with the commissioning of it, but you don't own the work at the end of the day, and there shouldn't be any financial share of it for you.
If I paid you, not that I want to do this, not that I have the capacity, but Bert, if I paid you more, would you be more? Would that be a possibility? I mean, I don't want to put you on the spot here of making, telling me what the additional fee would be, but just for next time.
Yeah.
Are you open to discussing sharing this if you were paid more?
Yeah, and that would depend too. I mean, like what I've seen is that certain ensembles have a publishing arm as well, that they make scores available to others and they promote the music. So if I thought that by doing that, you paying me a bit more, but also that your publishing arm could go out and promote these works so that there's other sources of revenue from that. Yeah, maybe I would be interested in you either taking some amount, or maybe you take some sort of administration fee on the work that you, or at least the money that you help to generate by having it promoted through your publishing arm.
So Bert, let's see how this goes. Let's see how this how the work goes, and then maybe let's reconnect about a potentially new arrangement regarding being more collaborative with respect to the future of this work. But let's keep this agreement to this, and let's have a conversation later about potentially other avenues to work together.
I think that would be the way I'd want to do it too, is just keep this one clean. And if there's, after the fact, I still have the publishing that I can deal with.
Yeah.
And we can cut a deal that way.
Well, I hope to be a good partner with you on this work, and we'll see what we can do next. But I understood that your position presently, and looking forward to seeing what we could do later, potentially.
That sounds great. And then we'll have a track record of working together too. So
yeah.
It helps. Okay, cool. I'm looking at thank you. And people have populated the chat with some things that I have that I was asking about. So including workshop fees, etc., performances, pre-post concert chats. So I think that's good to share. If somebody's getting hired, then it's always good to know that too, because then you charge a bit more for it. And it doesn't sound like you're being at all unreasonable in what you're asking for. So just with respect to royalties, in the model agreement, the composer is going to be entitled to 100% of the writer's share and 100% of the publisher's share. And without getting too deeply into that, it's like when I was talking about ensembles that have a publishing arm, it's like maybe you're willing to give up part of that publisher's share, sorry, not the chair. And so the commissioner, and not the venue where the musical work is to be performed, shall be responsible for all applicable performance right fees. So, it may be the administrative obligation for a venue to be paying those sorts of things. You need to have recourse against the commissioner for having done that, because they're the ones that are doing the contract with the venue. And so you don't have a contract with the venue. So in any event, it's important that you have that, and for reasons around the rights too, because these performance rights are they're non-exclusive rights. They're just rights to be paid something. So it makes it difficult for you as the composer to sue a third party to stop them from it. It's a complicated process, and that's why you need to have the commissioner, who does have an agreement with the venue, needs to enforce that. And so you have rights against the commissioner in that case. Would you say that's fair, Byron?
Yeah, I don't have anything else to add about that.
Okay, cool. Name and likeness. So this is typical stuff, but the commissioner shall have the right to use and display composer's name, likeness, biography, voice, and recordings thereof. And that would be subject to prior written approval solely for advertising, publicizing any live performances of the musical work by the commissioner. So again, you want to limit the rights that they get. Sure, you can use my name and likeness and biography, etc. But if not to promote your orchestra generally, it's really about promoting these performances. And if you want to use my name and likeness for anything else, you're trading on my good name. Let's talk about that too.
The key thing that you'd want to avoid here is a change that provides that you're giving the exclusive right to use your name or image or biography, which might kind of happen by accident. You never want to give the exclusive right to anybody to use your own name or image, but sometimes it kind of gets stuck in one of these clauses kind of by accident if someone's making some changes to it. So yeah, and it connects to the next section. The section 8, the name and likeness is what they can do, and then this section is about what they need to do.
Right, exactly. Okay. So name of the musical work and the credit, but the composer will have the name approval over the name. And then the composer credit would typically be a composed by credit or such other similar credit. And then it specifies where the credit would end up having to be placed. It's not good enough that they put it on a website and then never refer to you again. It's any print, digital, or any other form of communication must include that credit. Should be on a separate line immediately preceding or following the title of the music work in all programs, house boards, billboards, advertising, throwaways, etc. So again, specifying that you have to do these things and give me credit. The performer organization can't be larger or more prominent than the composer's name. We have that in there as a, and we see Byron and I both practice on the film and television side as well, and we're dealing with credits a fair amount. And these are all the sorts of things you just don't want it to be that your composer's name is written in a font that's so small as to be not noticeable or illegible. Those kinds of things. You're being given a meaningful credit in that case if somebody can actually see it, and it's not meaningful if they can't. And then when biographies are present in the program, the commissioner shall include the composer's biography as well. Okay, suspension and termination. So this is an important clause within most types of agreements like this, where the composer may suspend or terminate the agreement without notice if an event of force majeure, which will include all of these things, including COVID-19 or delays or defaults caused by common carriers. Like, it's every disaster scenario you can possibly think of, with the idea that if one of these things happens, then the composer can cancel and there's no liability that flows from that. Now, you might not get paid the full amount that you were supposed to get paid, and that's why you have a payment schedule is really, that's for the benefit of the commissioner, because otherwise, if you could get paid everything up front, I would recommend that you do. But most commissioners are not going to agree to that. And anytime you're doing creative work, people are going to want it stamped so that they're delivered something upon each payment, and they keep you incentivized to keep working on getting them the other things. But this is about suspension and termination. So you can terminate if any of these things happens. And
typically,
then,
just jumping quickly, typically the commissioner would want to have a variety of tools in their toolbox to pause or end the agreement. We didn't put that here because we don't want to, we don't want your commissioner to have those clauses, but they might add that. And this agreement is written to be favorable for you. So, if the commissioner comes back and says, well, we want to have more mutual clauses regarding things like this, the question becomes, is it reasonable? Is it appropriate in the circumstances? And sometimes it does come down to kind of who you're working with and how much they're paying you, or how much they're not, or how much less they're paying you than they really should be paying you. So all of the elements of any agreement, they do all relate to each other, and it depends on kind of who has more leverage in the situation sometimes. But just for clarity, typically the commissioner would want some additional protections, which we didn't want to automatically insert in an agreement that is more favorable for you, the composer. So that's that just quick comment on that.
Yes, that's right. And I mean, there are certain things where it's typical, like let's say, deemed approvals or whatever. There are certain things that are, kind of for the benefit of the commissioner, because in some ways you can't present something that's so completely one-sided that, it's not workable for the commissioner either.
Right.
But this is very definitely in favor of the composer based on the different ones that we've seen. So we try to do that because that's going to be your starting point for negotiation. So reps and warranties, I'm not going to take a lot of time with these. That's not to say that they're not important, but I think the most important things that come out of these representations and warranties, they are just basically statements that you're making that you're warranting are true. And both the commissioner and the composer are warranting them, although you have a bit more risk as a composer in making some of these statements. Like you're saying that you have all the power and capacity to enter into this and fully and freely performing all of your obligations under this. Now, and so this is the big one at the very end, which is the composer represents and warrants that the musical work shall not infringe upon or violate any rights of any third party or offend any statute or law, including any common law or statutory rights of any person, firm, or corporation. And that one is really you saying, this is original to me, and I'm representing and warranting that that's the case. And I'm noticing, and maybe Byron's noticing this too, but in the pop world, there just seems to be a plethora of litigation going on around who ripped off who. Even if there was no interaction between these folks, it's just whether it's sampling, etc. You have to know what's being put in there, and then other people are making claims with respect to copyright because, and this is more genre specific on the pop side of the world, or maybe hip hop or whatever. It's like the music uses a set of chord changes that has been used before, and they have to be because you're writing diatonic pop music like that, and there's only so many chord progressions that there are. This is important for you folks too, but if I'm going to give you guys a pat on the back, it's that originality is less in question whenever we're talking about this kind of art. It's like it really is a lot more original. So in any event, it's still an important one. I've seen avant-garde composers use recordings to make new music, etc., and it's done in a hopefully a transformative way. But that can get you start taking somebody else's work like that, and you probably need clearances and licenses to do that, or you're taking a risk. And indemnification is another one. And this is basically saying, look, anything that happens in terms of this agreement, if I breach the agreement and it causes you any damage, if my representations and warranties turn out to be false and it causes you damage, then we're going to indemnify you, which basically means it's kind of an insurance policy for the commissioner. But it goes both ways. And then there's the confidentiality provisions, which are pretty standard. It's like, so the terms of the agreement are going to be kept secret and confidential, except parties may disclose the terms to comply with laws or judicial orders. Normal report.
You don't want the commissioner to tell other people what your rates were.
Yeah.
That's kind of a key thing, right? I mean, you don't want, especially if you were giving someone, a deal, so to speak, or you're being paid less than what you should have been paid, which is unfortunately more common than it should be. You don't want this commissioner saying to some other organization, "Oh, I was able to pay this amount, so or get these payment terms or whatever else." So this does protect you. And that's why it's there.
Yeah. I
Now,
think it's important. Go
yeah,
ahead.
I mean, it's difficult. It's an agreement can only go so far in, what it leads to people doing. I mean, it deters people from saying this information, but it's not going to close someone's mouth or stop an email from being sent if someone sends something. But it goes kind of as far as we can. It goes. It's better than it not being said, and it's important that that everybody understands what's confidential and what's not. And the details of this agreement are to be confidential.
Right. Yeah, and you make a good point too, Byron, in that, I was saying sharing information as part of as part of a trade organization is a good thing. But this would make it this is here to protect you, but at the same time, it could hurt you if you specifically set out, exactly what the terms were and you made it public and that sort of thing. So it's best when you're talking about that kind of information with your colleagues that it's made a little bit less specific and more of a benchmark in the industry. And you could say something like, yeah, I know I got caught, or I know people who were paid this particular fee. Like, let's say I got paid 10,500 on something, and I won't say who is paying that, but that's like the kind of going rate for something, without intimating exactly who it is. You got to be careful about that kind of stuff. Also, I see that Helena had asked the question, what does indemnify mean? I'm hoping we took care of that. And so go ahead, Byron.
Yeah, I mean, it's essentially, so the representations and warranties, that's where you're saying you're confirming certain things, like that what you're doing is original. And the indemnification section is that you're covering someone for their loss if what you said wasn't true. So for example, if Burt composed this work and he's saying it's original, but part of the work is just a complete copy of some other work, which, Burt would never do. But if he did, and the creator of that other work goes to the commissioner and says, "Oh, I just attended this performance, and, this is actually a copy of like what I made for those people." And then if that person sues the commissioner can go after Burt to say, "You told me it was original. I have a loss now because this person came after me and they were right. I'm holding you responsible because you represented that it was original and you indemnified me, meaning you covered me for my losses with respect to things that weren't true, that you said were true." So that's kind of the connecting the dots between the representations and indemnity. And
I would add to that too, is like, me as a commissioner, I would have never allowed this to be performed publicly if I knew that.
Yeah.
And that's how I get in trouble, because I trusted what you had to say in your reps and warranties.
Yeah.
So,
It's completely reasonable that someone who's creating intellectual property in one form or another is confirming that what they're creating is original or is based on public domain work. And that's kind of the other part of it. That, I mean, the point here is we're saying it doesn't you're not taking someone else's rights. But to accomplish that, it's either original or you're taking something in the public domain. For example, something that was written by someone who died a very long time ago, let's say 200 years ago. I mean, it's the rule in Canada now is 70 years after death of the latest author. It went up from 50 to 70 because of the new NAFTA that we entered into. Came into law not that long ago, but it's now 70 years. But either way, if you created something if you adapted and arranged a work that's in the public domain, you are also on side with this agreement. So whether it's adapting or arranging a public domain work, or if it's creating a new work, you are on side with respect to your obligations here.
Yeah, great. And so I'm going to sort of flip through because we're sort of at 3 o'clock now, and I just want to make sure we get to a few of the things, but maybe we'll go quickly. I did want to get to the schedule as well, just because I think
Yeah.
there are some important things in there. We talked about survival, meaning these things in those particular paragraphs continue, including your rights, are ongoing and they don't just terminate with the end of the contract. Notices, which means, you got to give people notice and it's got to be sent to specific email addresses. Independent contractor just means that, you're not an employee of the contractor at that point. And likewise, you're not an employee of the commissioner, and the commissioner is not your employer. So assignment, this is another important one, because if you're not able to assign this means that you can't take your obligation to produce a score for these folks and subcontract it to somebody else. So, and that would be typical in this kind of an agreement. They're contracting for your creative services in that case. Governing law, this is going to be construed. Now, you can change this on the basis of where you are. I know that you're a national organization, but you can be province of British Columbia, federal laws of Canada applicable therein. And this was written with Canadian common law principles in mind. So I think it works for Quebec law as well, but you would change the governing law to Quebec at that point, or maybe that's a discussion that we need to have in the context of potentially the French agreement that we have.
The other related comment on governing law is that it's always preferable for you to have the law be governed by the province or territory that you live in. If you and the commissioner are in different parts of Canada, commissioner would probably want the agreement to be governed by the province by the province where they live, not where you live. It comes up in the context, among other things, of if there's a conflict. If someone needs to sue somebody else, for example, for non-payment, then a key thing like this relates to that, where it's a lot easier. You have more protection generally, and just easier for you to operate if the governing law is where you live. Probably not a deal breaker, but definitely an important thing. And some people say that the most important part of any contract, apart from who you're contracting with, is this section of where the governing law. It sometimes becomes more relevant if we're talking about a commissioner in, let's say, United States or in Europe. In those situations, it becomes more of a challenge if the governing law is some other country. Less of an issue province to province in Canada. But definitely your preference would be that any agreement you enter into, generally speaking, non-legal advice here, is that the governing law is where you are based.
Fair enough. Yeah, and often it's better. I've seen people try and do like a hybrid version of the governing law. It's like if the action is brought in Ontario, then Ontario law will apply, but if it's brought in the province of Manitoba, and that can lead to a mess. It's better to have one jurisdiction. You're probably better off in some cases having a governing law clause that is neutral. Often people use New York or California just because it's an entertainment law jurisdiction, and they know what to expect from it, and they're both going to be bound by it. We'll keep going here. English language. This one has been, the parties acknowledge that it's been drawn up in the English language, and then it's said in French as well. Illegality, it's like don't throw out the baby with bathwater clause, which is, it basically says if there's anything that's wrong with this agreement, where you're just going to remove that particular provision and interpret the rest of the agreement as if it didn't contain that provision. Entire agreement is another important one as well, because it basically says any other arrangements we had, verbal or otherwise, emails between us that said this or that, this takes the place of all of them. So what's said in this agreement is paramount, and it trumps everything else. And here's Schedule A. these are all the different things from a nuts and bolts perspective that, you guys are going to want to have to look at, because this is, they're really specifying what the duration, the general description of the work, instrumentation, the delivery date, delivery format of performance score, whether it's electronic portable document format. I've seen some of these where they still want physical, they still want engraving done. It can be electronic, but it's you have to look at these because these are the things, these are the requirements that you're going to be expect to meet rather, and it will, it could affect, the amount of time and your price. And then all the other details about the musical work as well. So performances, dates, venue, and then you have your milestone schedule, which would, affect other things like your payment schedule potentially, but, that's going to have the dates that you have met certain milestones by. And that's it. Thank you very much for having us. I think we've tried to answer the questions during the time, but if you do have other questions, I have a little bit of time. I don't know if you're available still, Byron, or if other people are available to stay on here for another 5 minutes, but I'm happy to stay on for a few minutes and ask and answer some questions. I see Catherine has a question.
Hi there. I have a little bit of an unusual situation. There was a commissioning contract that was completed 2 seasons ago with clear deliverables. It was created for a theater setting. But now what's happening is the creator of the text is planning to revise the work, and a theater is supporting this work. So they've brought us back on to do, I guess, another commission, but there are no deliverables. And, I'm not even sure how to frame that in this case because the work is going to go into workshop and we don't know what the deliverables will be as of yet.
Wow. So that's, oh, go ahead, Byron.
Well, I guess like the question, so one way to interpret this is, what are you being asked to do? And you can't really, it's difficult to agree to anything if you're not sure what you're being asked to do. Like, what are they asking you to,
We've been told verbally by the creator that there's not going to be new songs, it's going to be revisions, but none of that is in the contract, and I don't know if the theater would even agree to that. I'm not sure.
I guess kind of a general comment would be that if someone's not very clear on what they're asking for and not agreeing to include it in the agreement, then that's a problem and something that needs to be rectified or dealt with before anyone is able to accept a commitment. Before you're accepting to provide a commitment to do something, you need to know what you're doing. So that's kind of I don't know how helpful that is in the current situation, but that's someone could say to the other party, I can't agree to something, I don't know what it is.
Yeah. So would it be appropriate for us, because the contract is actually with the theater, would it be appropriate for us to say we need to know what our deliverables and expectations are before we can move forward and see where they go?
Generally speaking, in that kind of situation, that seems like an appropriate response. And if someone isn't given an answer, then it's difficult for anyone to agree to something that they aren't being told very clearly what it is. And the related concept is the concept of scope creep, whereby you're asked to do something without clear outlines of what it is you're being asked to do. And this is extremely common in a variety of settings, including but not limited to this one, where the more vague the deliverables are, or completely, just non-existent in terms of how they're presented, it creates a situation where someone says, well, you agreed to get me, you essentially you agreed to solve a problem or provide a solution. And I mean, there's continually more you have to do in order to, fulfill your mandate of helping us out. And that's, that's a problem in a variety of settings because, there's like no end date, essentially, potentially. Um, so, it's easy for me to say, oh, define expectations. And I know that, that's just not always possible, but definitely it's very difficult, as, I feel you kind of are agreeing. It's just difficult to agree to things if you don't know what you're being asked to do. And if they don't know yet, then, well, let us know when you know.
Can I ask one quick follow-up question? I'm sorry, I don't want to monopolize, but if the theater says no, it's just going to be revisions, would an appropriate fee schedule possibly be an hourly?
Yeah, I mean, definitely. So generally speaking, when you're not, when you're not sure of what it actually needs to be done, whether it's an hourly or a daily rate or something like that, one way to protect oneself in that kind of situation is to say that, in one form or another, let me know what you want me to do. My hourly rate is this, or my daily rate is this, but I can't guarantee that I'm going to be available, because you can't kind of put them. It's difficult to give someone priority when you have no idea what they want to do. And it may be that after a certain amount of time being spent, you just don't want to be doing it because it's just too much of what you're being asked to do is just not something that you want to be doing. So if someone can limit their obligations, but also clarify how they're being compensated, and preferably you're compensated upfront, like you're being, if it's a daily rate, and they're really not sure how long it could go. Well, okay, we'll prepay 5 days, and then we'll do 5 days and see where we're at. And then, I can't guarantee I can't guarantee a delivery schedule of timing, because I don't even know what you want yet. But here's my daily rate or my hourly rate, prepay for some time, if, or, depends kind of what the trust level is about being paid. But taking all those things into account will hopefully provide for an outcome that's acceptable to all of the parties.
Thank you so much. We do know that they are good for the money, and there is an end date on the
Okay.
contract already, so we're good. Thank you so much for your time.
Thanks for the question.
Kendra.
This is a super quick little question, but I was just wondering if your firm also did things like composer librettist agreements.
Librettist agreements. That's it's not something we've handled before, but I'm sure we could put something together if you're contracting with a librettist. The general principles of intellectual property and entertainment law would apply. So it's something that we could handle for you.
Wonderful. Thank you.
Yeah. Great.
So
So how are we doing, August?
I was just checking here to see if we have any more questions, and I'm not seeing anything in the chat, and I'm not seeing anything in the participant list. Oh, Sophie has a question.
Hi, Sophie.
Thank you. I was just thank you so much for this. It's been super informative, and it's such a great agreement. We're happy to have that. My question is in regards to when it comes to negotiating the contract. I'm glad you did a little role play there, but it often happens that composers are kind of there's definitely a power situation where the commissioner has a lot of weight, and then composers are kind of forced to accept some terms that aren't super accommodating. So what would be your advice when in a situation like that? I don't know if it's something you've encountered, or what kind of attitude should the composer go in with?
Well, I guess kind of fully appreciate the circumstances. And sometimes it's a matter of saying, well, I want to be balanced here, and I want to, have an arrangement that is consistent with industry standards and where you're at and where I'm at in our separate careers. And there are some things that you're asking for that I'm okay with, even though I don't like, but there are some things that are more meaningful for me and important for me to make sure that they're amended for, these reasons. Timeline. You're asking for, I don't want to rush, so I need this amount of time to fulfill it. I mean, a lot of it does come down to, financial, and at a certain point, further to one of Bert's earlier comments, in some situations, some people are asked to do things that just don't make sense financially. It's not worth the time, because of, competing interests in your life. And so, sometimes it's a matter of coming up with, okay, well, of all of these things that are being asked of me, here are the ones that are really a deal breaker, and I can't do this if these certain things are not amended to, something else. And sometimes people try to take advantage of other people all the time, unfortunately. And the role that I was playing was, a bit kind of aggressive at first, but then I was kind of open to, almost whatever Burt was asking for. But some people are, very tough to deal with, and other people are more accommodating. And I guess kind of the takeaway is to try to figure out, what you are able to agree with, and kind of build up all the things that they're asking for that you're accepting of. And even though you would accept it anyway, it's like, well, you've asked for these 10 things, but these 2 things are things that I really, they need to change in order for me to be able to do this. And, the more that you're kind of demonstrating all the things that you're agreeing to, it does help to, showcase a bit of a scale of, these are the things that I'm giving up that you want, but these, there's a fewer number of things that I need on my side. So, that's kind of, one strategy. And, it's not exactly an easy, it's kind of easy, again, easy for me to say, harder to do, but the more leverage anyone is able to create for themselves with respect to their work, it becomes an easier conversation to have. But that's easy for me to say. It's not something that's in practice is simple to do, and it takes a very long time in any craft, including this one, to be able to be in a position where you do have more leverage than the other party. But hopefully that's a little bit of assistance on it. Sometimes, I mean, in any form of art, there are an intellectual property generally. There's different kind of players in the ecosystem, like an agent or a representative of one form or another, or a manager. A lot of people, are their own everything. We wear all the hats. But sometimes it's possible, if you have a representative who's able to get you better opportunities than you otherwise would, and able to get you more money than you otherwise would. Sometimes there's a role for that kind of person, but it's very difficult to find an appropriate representative. The role that a lawyer plays is, I mean, we get involved in negotiations all the time, but you shouldn't need to have a lawyer to communicate to the other party what your needs are. But that is the role that lawyers play, among others, in this process. Bert, do you have anything to add?
Yeah, no, I thought that's great. I think the only other thing I would say is, and you've alluded to this, but it's like, you be flexible, but at the same time, it's important, especially if you're negotiating on your own, to have an idea of what your sort of limits are up front, like what's the cutoff, and and again, easy for us to say, but maybe it's a question of, well, I just can't accept the commission if it doesn't pay this much, or I don't get this much artistic control, or there's just certain things that you can't. There's a group of things that you can negotiate, and then there's a limit past which you can't negotiate, and then if your negotiation is defined by those principles, then when to stop negotiating with them, and basically said that's really it. That's all I can offer.
That's actually really helpful. Thank you so much for the tips.
Great.
It's tough. It's very tough. It's hard for people to. It's hard for some people to be, promoting themselves, and to tell people that they're of value. So it's, for some people it's easy, and so for some people they kind of put themselves on a higher path. They give themselves more value than maybe they should have. But it is definitely a difficult process on someone by themselves to try to get what they deserve. It's a kind of a lifelong process, but
Yeah. If I have to generalize about composers and of this genre of music, it's like they're more on the I'm not going to fly my own flag all the time kind of thing. So I feel for you guys.
the last thing I'd say about all that is, if you don't ask, you don't get.
It's true.
And that's a common thing with, it's common among the arts and beyond generally, but it is also relevant in this context. So we did put Burt's email in there. We put our website, and I thank you for the people so far who have followed us on Instagram. But if you have any further questions, feel free to be in touch. And as Burt said, if you have any suggestions of types of clauses that you'd like to see in here, then we can work together to provide those suggestions to the group with amendments over time of the template.
Great.
Fantastic. So I not seeing any more questions. We're coming up on 3:30 here, so probably people are starting to take off. So we'll probably wrap up. I just wanted to say, I want to underline what Sophie said, that not only was the agreement fantastic, but this was a really, really helpful workshop, especially the sort of pretend negotiation. I thought was exceedingly helpful. It was much more useful than just going through the agreement. And I think as Burt also pointed out, this is not a skill at which many of us excel at. So seeing a little example of it, I think, is particularly helpful. So I'd just like to thank both Burt and Byron for your time and for your knowledge and for your work on this. And we're incredibly grateful that we now have this resource at our disposal, and that hopefully many people will be able to watch this recording and learn from it. So yeah, thank you so much. That was really fantastic.
Thank you. It was our pleasure being here. Thank you so much.
Fantastic. Okay.
Bye.
Bye,
Bye.
folks.
Take care.